Court has set aside the order of stay of execution granted by the Port Harcourt Division of the Court of Appeal, which the All Progressives Congress hung onto to conduct its ward, local government and state congresses in Rivers State.
Absolutely. In its ruling, the Apex Court described the conduct of the Congress as a serious violation of court order and berated the Court of Appeal for nullifying a High Court order against the Congress. Following an ex parte application by aggrieved members of the APC, a High Court in Rivers State instructed the party to suspend plans for the conduct of its local government Congress, pending the determination of the substantive application, alleging the marginalization of some of its members. And instead of complying with the court order, the APC appealed the ruling and proceeded to conduct its primaries. And now, the now avoided Congress produced the currently recognized chairman of the APC in Rivers, Ojukaya Makri, an ally of Transport Minister Rotimi Amechi. Meanwhile, Senator Magnus Abe, in his reaction to the ruling, described the judgment as historic and also termed those parading themselves as candidates of the party political rascals, to put it lightly. Well, we've been joined by a lawyer, Rivers Effiong. Good morning and thanks for joining us.
Good morning. Thank you for having me.
Yeah, but since this is a very serious issue, I was going to say, more common, but let's just leave that.
It's interesting what has happened in Rivers State.
Yeah.
While Magnus Abe is celebrating, Amakri on the other side has a totally different interpretation for the judgment of the Supreme Court. Now, help us understand this. If congresses held, have been cancelled, if the Supreme Court is saying that the Court of Appeal erred, by subverting the court order of the Federal High Court, does that not completely nullify the primary election of the APC?
Let me begin by saying that the celebration of Senator Magnus Abe, for me, is neither here nor there, because the pronouncement of the Supreme Court is a lose-lose situation for both factions in the states. The pronouncement does not confer candidature on Senator Magnus Abe. It does not make him or his faction eligible to be sponsored by the APC to represent the party in the 2019 election. The Supreme Court decision or ruling is not ambiguous. It shouldn't result in conflicting interpretation.
But it's still, I mean, both sides are still reading this differently from their standpoint.
Yes, because politicians will always try to give varied interpretation to court pronouncements to suit their personal interest. To start with, the High Court of Rivers State made orders on the 11th and 30th of May. The first ex parte order was made on the 11th of May, restraining the APC from holding ward, local government and state congresses in the state.
Yes.
Upon the application of 23 members of the party in the state who complained that they were excluded from participating in the congresses.
Absolutely.
That order was valid. That order was subsisting. The APC, in disregard to that order, proceeded to organize congresses on the 19th, 20th, and 21st of May. On the 30th of May, the High Court of Rivers State reaffirmed its earlier ex parte order made on the 11th. Aggrieved by this, the APC proceeded to the Court of Appeal, seeking a stay of execution of the order of the High Court, restraining it from holding congresses. That appeal, that application to the Court of Appeal was favorably granted and considered. On the basis and on the strength of the clearance given by the Court of Appeal, the APC went ahead to hold congresses, which to them was valid because the Court of Appeal had said the order restraining them had been set
aside, or
The stay of execution.
So is the Supreme, I mean, of course you cannot question the decision of the Supreme Court, just so that we can, the Supreme Court is right then. in saying that the appeal court actually erred and acted in bad faith by, granting the APC the prayers at the appeal court.
Let's even note that the decision of the Supreme Court is not on the substantive judgment of the High Court. It's not on the substantive suit.
Okay.
It is on an interlocutory appeal by the Magnozabe faction on the question of stay of execution. The Supreme Court has not pronounced on the legality and the correctness or the propriety or otherwise of the judgment of the High Court. That matter is still at the Court of Appeal.
Aha.
What the Supreme Court has said is that the Court of Appeal ought not to extend the execution of the judgment of the High Court. The implication in law is that since the Supreme Court has now ruled that there was no basis for the Court of Appeal to extend the execution of the judgment of the High Court, it means that the primary held by the APC in Rivers State remains invalidated.
Which of the
having
primaries?
Been reaffirmed by the final judgment of the High Court.
Just a minute, because we need to help people understand this.
Yeah.
On one hand, right, the Supreme Court is saying that the party should return to status quo of May 11, right? Pending the determination of the substantive suit.
Yes.
But you also recall that the Rivers State High Court had, in a ruling on May 30, nullified the ward and local government congresses, as it were. The Magnus Abbey faction is saying it was after that substantive suit that it went ahead to conduct its own primary. Does that also make that the Supreme Court order has nullified its own primary?
No, you can't have two primaries by a political party. Only the National Working Committee of a party can organize a primary. The Supreme Court has resolved that point in plethora of cases. That is why I started by saying that the celebration of Magnus Abbey is neither here nor there. Okay. It is a lose-lose situation. The Supreme Court has not said Magnus Abbey, for example, is the gubernatorial candidate of the APC.
Should be the beneficiary of that. Okay.
What the Supreme Court is saying is that the APC has not held primaries. The APC could not have held congresses because the orders made restraining them ought not to have been stayed.
Does the Supreme Court need to go further in clarifying some of these ambiguities? Because the Ojukaye-led faction is saying that the Supreme Court did not set aside his chairmanship of the Rivers APC and the Congress that it had conducted.
That is very funny to me. How did he become the chairman? It was as a result of the Congress that was held, which the High Court had restrained the APC from holding. In any case, what was the basis of the pronouncement of the Supreme Court? The Supreme Court said, one, that some members of the APC, as reported, I've not read the decision, but as reported, some members of the APC had launched an attack on the court to restrain the High Court from giving that order. But the High Court proceeded to give that order. And that in reliance on the earlier decision of the Supreme Court in 1986, in the case of military governor of Lagos State and Odumeko Ojukwu, where Ojukwu had made an application to stop the then military governor of Lagos State from evicting him from his property, which he claimed after returning from when the civil war ended. Ojukwu got that order. When the motion for interlocutory injunction came up, the court declined to grant Ojukwu that application. Ojukwu went to the Court of Appeal, filed a notice of appeal and served it on the Lagos State government. While that appeal was pending, the Lagos State government had him evicted from the property. Ojukwu now brought another application asking that he should be restored and reinstated in the property. Rather than complying with the order of the Court of Appeal to reinstate into the property, the Court of Appeal went to the Supreme Court to appeal against that order. The Supreme Court said, no, that you're already in disobedience of the order of the Court of Appeal. You cannot come to us with dirty hands to seek equity. Therefore, the order removing him from the property was invalid. The Supreme Court relied on that decision to say the Court of Appeal ought to have followed the doctrine of stay decisis.
So what are the implications of this appeal court, the larger implications really of the appeal court ruling when the matter was still in court?
For me, what the appeal court did was an exercise of discretion. The Supreme Court said that discretion was not exercised judicially and judiciously. I have made the point that the substantive suit regarding the judgment of the High Court is not even before the Supreme Court. It is still at the Court of Appeal. The Court of Appeal will now have to determine whether the actual judgment of the High Court is valid or not. The only hope for the other faction, the Amechi faction now, is if the Court of Appeal, one way or the other, finds on the substantive suit that the High Court was wrong. But I believe this matter will get to the Supreme Court. But as of today, nobody can claim to be a candidate of the APC in Rivers State.
I'm concerned about the decision of the Court of Appeal because the Supreme Court Justice Unweze held that the action of the appellate court amounted to sacrilegious exercise of judicial discretion, saying it committed, quote, gross insubordination by refusing to abide by precedents already set by the Supreme Court. Apparently, it's implying that the appeal court erred in its judgment. Shouldn't someone get sanctioned for this? Because of the implication of the turn of events. Everyone seems to be confused now.
The Supreme Court even said the learned justices of the Court of Appeal, by declining to follow the precedent, the state decisis, in the case of military governor of Lagos State and Ojukwu, which I have explained what transpired,
cited, yes.
decided by the Supreme Court in 1986. And of course, the subsequent case of Odugwu and several other cases, where the Supreme Court has emphasized the principle that when the court has given an order, you cannot disobey that order and still go to a higher court to seek relief, which is what happened in this case, that the Court of Appeal ought to have followed that precedent. But no matter how we look at it, what has happened is that the APC, in contravention of the order of the court, because whether a court order is valid or not, there is a strong argument by some lawyers that the order of the High Court of Rivers State ought not to have been made in the first place, because there are precedents of the Supreme Court saying that the court should not interfere in the intra-party affairs of political parties.
So in other words, was the appeal court in contempt?
That's exactly what I'm asking, that in a case where a court errs and has, impacted negatively on the turns of events politically, who takes the responsibility? Shouldn't someone get sanctioned? Because Supreme Court is making us feel like this is plain now. The Court of Appeal shouldn't have gone that way.
No, that is why the Court of Appeal is not a court of last resort. That is why it is an intermediate court between the High Court and the Supreme Court, which implies that there is a right of appeal to the final court, the highest court of the land. The Court of Appeal decision is not final. A party who is aggrieved has the right to appeal. Whether the pronouncement of the learned justice of the Court of Appeal amounts to gross misconduct is not for me as a lawyer to say. The important thing is that the Supreme Court has overruled the Court of Appeal on the question of stay of execution.
Does the Supreme Court judgment, as it is now, changes the insinuation that appealing a court decision automatically culminates in stay of execution?
No, it does not, because the law is very clear on that an appeal does not operate as a stay of execution. I think that is section 17 or 18 of the Court of Appeal Act. When a party has filed an appeal, that appeal does not automatically operate as a stay, except where that appeal is accompanied by a motion for stay of execution. But in the case of Rivers State, in the case of Rivers State, the question is neither here nor there. That doesn't even arise, because there was already an order of court restraining the APC from proceeding with the Congresses. And the Court of Appeal now stayed that order of the court. The APC went ahead to hold primaries. Of course, the High Court came back to say, no, this ought not to have been done. The Supreme Court is now reaffirming the position taken by the High Court. While this is important, is that the APC was in contempt. The APC ought not to have proceeded with the and this is a lesson
to start with.
What the Supreme Court has done in this case, to me, is a clear message to political parties and political actors that rule of law remains the cardinal principle of a democratic process, and that political parties in the process of nomination and selection of their candidates should act within the law, should adhere to court order, whether that order is valid or not, until set aside by a higher court.
Okay, so now the Ojukai-led faction, who seems to be the loser, but as far as you're concerned, both sides
it's a lose-lose situation.
It's a lose-lose situation. They are asking, that the Supreme Court judgment was only an academic exercise.
No.
In their words, that's what they have said.
Strong exception to that.
Since the Supreme Court did not make pronouncements on the other issues, and that the state High Court had given final judgment on them. So should the appeal court continue with the cases before it now?
No. It is derogatory for him to describe the pronouncement of the highest court of Nigeria as academic. For me, I find that extremely insulting to the learned justices of the Supreme Court in a panel chaired by the Honorable Chief Justice of Nigeria. The Supreme Court was not embarked on academic exercise. If the question before the Supreme Court was academic, the Supreme Court would not have even determined it. Election matters, whether pre-election or post-election, are still generic in nature. So the question of academic does not even arise. Because even after election takes place, like we had in Amechi's case in 2008, the court can still look into the circumstances of the emergence of the candidates.
But what they're saying
so
precisely here,
academic.
what they're saying precisely here is that the Supreme Court judgment was on the stay of execution his faction got from the appeal court, not on the decision made by the High Court.
I've also made that point, that the substantive appeal is still before the Court of Appeal. What the Supreme Court is saying is that the judgment of the High Court as at today is in effect, is effective and valid. It has not been stayed. Therefore, there is no basis for anybody to say as at today that I am the candidate of the APC in Rivers State, except the substantive appeal before the Court of Appeal is determined in their favor.
Where does this lead? Where does this take all of this now with the Supreme Court judgment, and you still have this vagueness, or is it just playing the ostrich on the part of both sides involved in this case? What next then? Should there be a return to status quo ante, or what?
There's already a return to status quo. Once the Supreme Court has given a pronouncement, it comes into force immediately. And I have said clearly that today, APC has no candidate in Rivers State, except the Court of Appeal holds otherwise and set aside the substantive judgment of the High Court.
Now, what Magnus
Abe or predict what that pronouncement is going to be. But I strongly believe as a legal practitioner that by the tenor of the decision of the Supreme Court, the Court of Appeal will be seriously guided, strongly guided in determining the appeal before it, particularly on the question of contempt, because the Supreme Court took time to correct the APC for acting in contempt of the subsisting and valid orders of the High Court.
Both the APC and, of course, the appeal court.
Exactly, because I don't think Magnus Abe, can really say is the winner of this. He's only happy because the other faction has not gotten what he wanted.
Apparently, that judgment, the High Court judgment, has been appealed, right? And the question right now is that even if that judgment is set aside, does it change the fact that the decision to hold the Congresses was valid as at the time it was violated?
I just made the point that I don't want to preempt the Court of Appeal. But as a lawyer, I believe the Court of Appeal will be strongly guided in determining the substantive appeal, having regard to the tenor of the interlocutory decision given by the Supreme Court on the question of stay, vis-a-vis the issue of contempt. That in law we say what is done contrary to law is deemed not to have been done at all. You cannot put something on nothing and expect it to stand. USC and MAFO.
According to you now, APC does not have candidates.
As of today.
Now let's bring in the INEC timetable in. They have to produce candidates. In fact, as a matter of fact, within a particular time frame. How does that work?
By Section 87 of the Electoral Act, a political party wishing to sponsor candidates for election in Nigeria can only do so through two processes. Only two situations that are cognizable, are recognized in law. Either through a direct primary or through an indirect primary or special congress. In the case of Rivers State, for example, in the governorship primary that produced Tony Cole, they adopted indirect primary or special congress. A party cannot sponsor a candidate without holding either a direct or an indirect
What
primary.
about consensus?
Consensus candidate is unknown to law. What parties call consensus candidate is a situation where only one aspirant contests for the candidature of a political party. And even when that is the case, that party must still hold a primary to affirm the nomination of that person.
How does that apply in the case of the sole presidential candidate of the APC?
The same thing. That is why the APC held a congress in Abuja, at the Eagle Square, to confirm the nomination of Buhari. Buhari couldn't have been the presidential candidate of the APC without the primary taking place in Eagle Square.
Can a primary election now still take place in Rivers State?
I don't think so.
Does that automatically mean that APC has lost out in the governorship election?
Well, it is a 50-50 chance. I have said the substantive appeal is still at the Court of Appeal. That appears to be the only window for the APC. Again, they can't even substitute some people are proposing, why not bring a neutral person? Is it possible for both factions to come together and pick somebody other than Magnus Abe and Toye Cole? And I have said that may not be possible because they cannot subvert the electoral provision section 87. Section 33 of the Electoral Act even forbids substitution of candidates, except in the case of death or withdrawal by candidates. So as that today, it is a very difficult situation for the APC.
Truly a difficult situation. I guess we'll have to leave it there. Inibege Ifyong, a lawyer there. Of course, you can already see that. Very, very obvious.
Thank you.
We are
so
set
much
for an unprecedented decision
Absolutely.
as regards this case by the Supreme Court.